And again, in 1833, Connecticut passed another law which made it penal to set up or establish any school in that state for the instruction of persons of the African race not inhabitants of the state, or to instruct or teach in any such school or institution, or board or harbor, for that purpose, any such person, without the previous consent, in writing of the civil authority of the town in which such school or institution might be. And it appears by the case of Crandall versus the state, reported in 10 Connecticut Reports, 340, that upon an information filed against Prudence Crandall for a violation of this law, one of the points raised in the defense was that the law was a violation of the Constitution of the United States, and that the persons instructed, although of the African race, were citizens of other states, and therefore entitled to the rights and privileges of citizens in the state of Connecticut. But Chief Justice Daggett, before whom the case was tried, held that persons of that description were not citizens of a state, within the meaning of the word citizen, in the Constitution of the United States, and were not therefore entitled to the privileges and immunities of citizens in other states. The case was carried up to the Supreme Court of Errors of the state, and the question fully argued there. But the case went off upon another point, and no opinion was expressed on this question. We have made this particular examination into the legislative and judicial action of Connecticut because, from the early hostility it displayed to the slave trade on the coast of Africa, we may expect to find the laws of that state as lenient and favorable to the subject race as those of any other state in the Union. And if we find that at the time the Constitution was adopted, they were not even there raised to the rank of citizens, but were still held and treated as property, and the laws relating to them passed with reference altogether to the interest and convenience of the white race, we shall hardly find them elevated to a higher rank anywhere else. A brief notice of the laws of 2 other states, and we shall pass on to other considerations. By the laws of New Hampshire, collected and finally passed in 1815, no one was permitted to be enrolled in the militia of the state but free white citizens, and the same provision is found in a subsequent collection of the laws, made in 1855. Nothing could more strongly mark the entire repudiation of the African race. The alien is excluded because, being born in a foreign country, he cannot be a member of the community until he is naturalized. But why are the African race, born in the state, not permitted to share in one of the highest duties of the citizen? The answer is obvious: he is not, by the institutions and laws of the state, numbered among its people. He forms no part of the sovereignty of the state, and is not therefore called on to uphold and defend it. Again, in 1822, Rhode Island, in its revised code, passed a law forbidding persons who were authorized to join persons in marriage from joining in marriage any white person with any Negro, Indian, or mulatto, under the penalty of $200, and declaring all such marriages absolutely null and void, and the same law was again reenacted in its revised code of 1844. So that, down to the last mentioned period, the strongest mark of inferiority and degradation was fastened upon the African race in that state. It would be impossible to enumerate and compress in the space usually allotted to an opinion of a court the various laws marking the condition of this race, which were passed from time to time, after the Revolution, and before and since the adoption of the Constitution of the United States. In addition to those already referred to, it is sufficient to say that Chancellor Kent, whose accuracy and research no one will question, states, in the 6th edition of his Commentaries, published in 1848, 2 volumes, 258, Note B, that in no part of the country except Maine did the African race, in point of fact, participate equally with the whites in the exercise of civil and political rights. The legislation of the states therefore shows, in a manner not to be mistaken, the inferior and subject condition of that race at the time the Constitution was adopted, and long afterwards, throughout the 13 states by which that instrument was framed, and it is hardly consistent with the respect due to these states to suppose that they regarded at that time, as fellow citizens and members of the sovereignty, a class of beings whom they had thus stigmatized, whom, as we are bound, out of respect to the state sovereignties, to assume they had deemed it just and necessary thus to stigmatize, and upon whom they had impressed such deep and enduring marks of inferiority and degradation, or that when they met in convention to form the Constitution, they looked upon them as a portion of their constituents, or designed to include them in the provisions so carefully inserted for the security and protection of the liberties and rights of their citizens. It cannot be supposed that they intended to secure to them rights and privileges and rank in the new political body throughout the Union, which every one of them denied within the limits of its own dominion. More especially, it cannot be believed that the large slave-holding states regarded them as included in the word citizens, or would have consented to a constitution which might compel them to receive them in that character from another state. For if they were so received, and entitled to the privileges and immunities of citizens, it would exempt them from the operation of the special laws, and from the police regulations which they considered to be necessary for their own satiety. It would give to persons of the Negro race, who were recognized as citizens in any one state of the Union, the right to enter every other state, whenever they pleased, singly, or in companies, without pass or passport, and without obstruction, to sojourn there as long as they pleased, to go where they pleased at every hour of the day or night without molestation, unless they committed some violation of law, for which a white man would be punished. And it would give them the full liberty of speech in public and in private upon all subjects upon which its own citizens might speak, to hold public meetings upon political affairs, and to keep and carry arms wherever they went. And all of this would be done in the face of the subject race of the same color, both free and slaves, and inevitably producing discontent and insubordination among them, and endangering the peace and safety of the state. It is impossible, it would seem, to believe that the great men of the slave-holding states, who took so large a share in framing the Constitution of the United States and exercised so much influence in procuring its adoption, could have been so forgetful or regardless of their own safety and the safety of those who trusted and confided in them. Besides, this want of foresight and care would have been utterly inconsistent with the caution displayed in providing for the admission of new members into this political family. For, when they gave to the citizens of each state the privileges and immunities of citizens in the several states, they at the same time took from the several states the power of naturalization, and confined that power exclusively to the federal government. No state was willing to permit another state to determine who should or should not be admitted as one of its citizens, and entitled to demand equal rights and privileges with their own people, within their own territories. The right of naturalization was therefore, with one accord, surrendered by the states and confided to the federal government. And this power granted to Congress to establish an uniform rule of naturalization is, by the well-understood meaning of the word, confined to persons born in a foreign country, under a foreign government. It is not a power to raise to the rank of a citizen anyone born in the United States who from birth or parentage, by the laws of the country, belongs to an inferior and subordinate class. And when we find the states guarding themselves from the indiscreet or improper admission by other states of emigrants from other countries, by giving the power exclusively to Congress, we cannot fail to see that they could never have left with the states a much more important power, that is, the power of transforming into citizens a numerous class of persons, who in that character would be much more dangerous to the peace and safety of a large portion of the Union than the few foreigners one of the states might improperly naturalize. The Constitution upon its adoption obviously took from the states all power by any subsequent legislation to introduce as a citizen into the political family of the United States anyone, no matter where he was born, or what might be his character or condition, and it gave to Congress the power to confer this character upon those only who were born outside of the dominions of the United States. And no law of a state, therefore, passed since the Constitution was adopted, can give any right of citizenship outside of its own territory. A clause similar to the one in the Constitution, in relation to the rights and immunities of citizens of one state in the other states, was contained in the Articles of Confederation. But there is a difference of language which is worthy of note. The provision in the Articles of Confederation was that the free inhabitants of each of the states, paupers, vagabonds, and fugitives from justice, excepted, should be entitled to all the privileges and immunities of free citizens in the several states,